This video is an introduction to fundamental rights which are enshrined in Part 3 of the Constitution from Article 12 to Article 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of United States of America, that is, Bill of Rights. Part 3 of the Constitution is rightly described as the Magna Carta of India. It contains very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our constitution are more elaborate than those found in any other country in the world, including United States of America. The fundamental rights are guaranteed by the constitution to all persons without any discrimination. They uphold the equality and dignity of the individuals. Along with this, fundamental rights also uphold the larger public interest and unity of the nation. Also, they prevent the establishment of an authoritarian and despotic rule in the country. But now the question arises, why the fundamental rights are named so? Basically, fundamental rights are guaranteed and protected by the Constitution, which is the fundamental law of the land. Apart from this, these rights are fundamental also in the sense that these are the most essential rights for all-round development of the individuals, whether it is material, intellectual, moral, or spiritual. So we are now clear why these rights are called fundamental rights. Originally, the Constitution provided for 7 fundamental rights. Right to equality, which is enshrined under Article 14 to Article 18. Then we have right to freedom under Article 19 to Article 22. Right against exploitation under Article 23 and Article 24. Then we have right to freedom of religion under Article 25 to Article 28. Cultural and educational rights under Article 29 and Article 30. Right to property under Article 31 and right to constitutional remedies under Article 32. This right to property was deleted from the list of fundamental rights by the 44th Amendment Act 1978, and then it was made the legal right under Article 300A in Part 12 of the Constitution. So at present there are only 6 fundamental rights in our Constitution. Now we will have a look at the features of fundamental rights in these 12 points. All of these fundamental rights are available to the citizens, but some of the fundamental rights are also available to foreigners or legal persons like corporations or companies. And all the fundamental rights are available against the arbitrary action of the state. However, some of the fundamental rights are also available against the action of private individuals. Apart from this, these fundamental rights are justiciable, which means whenever these rights are violated, persons are allowed to move to the court for their enforcement. Aggrieved person can directly go to the Supreme Court and not necessarily by the way of appeal against the judgment of High Court. Out of these fundamental rights, some of the fundamental rights are negative in character. That is, they place limitation on the authority of the state, while others are positive in character. That is, they confer certain privileges on the person. And one more important point to note here is that these fundamental rights are not absolute but qualified. The state can impose reasonable restrictions on them, but here a question arises: who will decide whether the restriction imposed are reasonable or not? For this, our constitution has given this responsibility to the courts to decide whether these restrictions imposed are reasonable or not. So in this way, we can say that courts strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. One more thing, fundamental rights can also be suspended, and they can be suspended during the operation of national emergency. And during this time also, the rights guaranteed under Article 20 and Article 21 cannot be suspended. Apart from this, the 6 rights guaranteed by Article 19 can be suspended only when the emergency is declared on the grounds of war or external aggression, that is, during external emergency, and not on the grounds of armed rebellion, that is, internal emergency. By now we have seen 7 features of fundamental rights. Let's look at the 8th feature, which says Article 31A, 31B and Article 31C can limit the scope of fundamental rights. And if we talk about members of armed forces, paramilitary forces, police forces, intelligence forces or any similar forces, their fundamental rights can be restricted or abrogated by the parliament. And parliament can do so under Article 33. Another article, Article 34, allows Parliament to restrict the application of fundamental rights while martial law is in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order. It is different from the imposition of national emergency. And we should also remember that fundamental rights are not sacrosanct or permanent. Parliament can curtail or repeal them, but Parliament can do so only by a Constitutional Amendment Act and not by any ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. This was point 11. Let's look at the point 12. Most of the fundamental rights are directly enforceable, which means self-executory. But some of the fundamental rights can only be enforced after Parliament passes such a law. And such a law can only be passed by the Parliament and not by the state legislature, so that the uniformity throughout the country is maintained. So in this video, we have seen an overview of fundamental rights and some of its main features. Thank you for watching this video.